Hello, everyone. Welcome to the first Agenda IDS of the year. I'm Patricia Porto, the Academic Coordinator of Dannemann Siemsen Institute. Agenda IDS is an online event in which we address important topics regarding intellectual property, law, and technology. I always invite experts on the subject to share their experience with us. And those who miss the live event will be able to access the record content available later on Dannemann Siemsen Institute website. And today, we will debate about the growing influence of dupes industry, such as cosmetic, fashions, and consumer goods, as well as the impact on IP right holders. And to discuss this topic today, we invite two experts on the matter. And please, let me introduce our guests. Today with us, we have Alastair Gray. Welcome, Alastair. Alastair is the International Trademark Association Director of Anti-Counterfeiting and is the staff liaison of over 340 volunteers of the IDS Anti-Counterfeiting Committee, which develops the association policies and positions on combat trademarking counterfeiting worldwide. Alastair is also currently signed as an expert in the Lipkus Observatory Expert Groups on cooperation with intermediaries, which studies, among other subjects, infringement in social media. We also welcome David Lipkus. Welcome, David. David is a lawyer and founder of Lipkus Law LLP in Canada. David has dedicated his practice to stop infringers from using or reproducing his clients' intellectual property without permission in Canada and online. David's principal focus is on intellectual property brand protection for trademarks, copyrights, and industrial designs. And to moderate the event, we invite Rafaela Borges Walter Carneiro. Welcome, Rafaela. Rafaela is a lawyer and partner at Dannemann Siemsen. She holds an LLM in intellectual property law from Philipps Universität Marburg in Germany. She works at all levels of trademark protection process, and her expertise includes the strategic management of national and international portfolios. And I would like to thank very much our guests and the audience for being here today with us today. And now I will give the floor to Rafaela. Please, Rafaela.
So hi, guys. Good morning. I will be short. So it's a pleasure to moderate this panel, having David and Alastair with us. We'll talk a lot about dupes. Dupes is a short for duplicates, and there is a lot of discussion on how dupes is going to be treated as an infringement or not. The thing is that the dupe market has exploded in popularity, mainly with the influencers. And on platforms like TikTok or YouTube, the hashtag dupe has surpassed 4 billion views, showing how these products are really capturing the attention of consumers, especially the younger generations. So there is an excellent chance to have David and Alastair here to go ahead and think and propose this discussion with us. So I will start our conversation asking a question to David. And David, how did the dupe culture begin? And what do you think is the impact on social media?
That's a great question. Thank you for asking. I just want to start, and I obviously think Alastair will agree with me. We want to thank you very much for asking us to talk, and we're really excited to provide our 2 cents on dupe culture. Well, just to begin, and I'm going to tell a really quick story about myself, but I started practicing as a lawyer in 2009, and I was very active on social media because I use social media in my personal life. And when I became a lawyer on the, what I'll call counterfeit, infringement, intellectual property side, there were issues that brands were having at the time. And the biggest issue that was facing from an infringement perspective that brands were facing was MySpace. And just to put in perspective, the start of dupe culture is as a result of the popularity of social media. And if we go back to the 2009, 2010 era, let's think about what social media was all about. Social media was a way for individuals to interact. Historically, there was messaging, there was email, but what social media did is it drove the ability for pictures and then videos, and it was a more fun format for people to really come together and talk with each other and talk about like-minded subjects and really just be together as a society. Didn't matter if I was in Brazil or Canada or in the US or in the Netherlands, we could all talk at the same time together live. So let's think about what the world was like back then. What ended up happening is you had really popular people. And let's think about the grand scope of social media at the time. And believe me, this will lead into dupe culture. There's Ronaldo, over 1 billion followers collectively with all his social media. Taylor Swift, Selena Gomez, Justin Bieber. There were really popular people that many people around the world wanted to follow. So what happened was brands decided I can leverage the popularity of that star. And what they started doing was advertising naturally and organically through these really popular stars. For example, if Ronaldo put, a bottle of Coca-Cola, or pick any brand, if they would market that brand on their social media, it had vast reach. And it was never seen before. It used to be billboards and television advertisements, but social media changed the game. And what happened was you would have these massive followers that brands accepted and wanted to market through. And then everyone went onto social media, right? You think fast forward to today, everyone's there. What ended up happening is you had a whole market of influencers. And it wasn't just the big stars. You could have an account with 1,000 followers, and that could be very valuable to a brand because what they would market on their channel, on their social media platform, spoke from a consumer perspective to the followers. So those followers would want to buy whatever was being advertised by that influencer, whether it was a big influencer like a Ronaldo that we think of, the biggest arguably, or a small micro influencer which had limited following. So what ended up happening is that the brands accepted this form of communication. And what flowed from that is not only would brands, by way of example, market, then you would have counterfeit sellers market. And when you had the brands there and the counterfeiters there, what ended up happening, fast forward to today, is you would then have the duplicate sellers as well, which is arguably in between, and we'll talk a little bit about where they fit within it. But you would have the duplicate sellers, you would have them market through the use of social media to the different consumers. And at the end of the day, what is this all about? It's about consumer behavior. And that to me is how this all started, was the power of the what I'll call micro influencers in marketing to consumers, because whatever they say you should buy, the consumers would follow.
Perfect. So going back to you, how does the IP law differentiate between inspiration, imitation, and infringement in the context of dupes? I think that's maybe the most difficult question.
The million dollar question, Rafaela. I like it. Thank you. So a couple things. Number one, which is important for me to say, the laws are different in different countries. So you have to be mindful. If you're going to look at this from a global issue, which we are today, you must recognize that the law in Canada, as it relates, for example, to brand dilution or trademark infringement or counterfeit, is different from the US, which is different from Brazil, which is different from the Netherlands, which is really different depending on the globe. And then you add in that we're dealing with an online issue, and it just complicates things. Having said that, what I want to do is look at this from the perspective of a pendulum swinging, and where does it go from inspiration to infringement, or is it even a counterfeit versus a dupe? And for me, I like to talk from personal experience. So when it comes to inspiration, my favorite designer is the late Virgil Abloh. And for those that aren't familiar, go Google him. To me, he's the best designer, the coolest from my generation, my vintage. And I'm going to tell a story from when he was fashion director at Louis Vuitton, but he came out with the fashion runway, and he stitched these animal designs onto products. And I recall at the time that people were really upset. There were these plush figures on designs, and this artist, Van Bierendonck, came out and said, "Why didn't you collaborate with me? That is my design, and you stole from me." And Virgil Abloh publicly came out and said, "I may be inspired by lots of other designers, but rest assured, everything I look at every day, architecture or different artists, everything in the world inspires me to create what I've created." And so it's really important to think about it from that perspective, that if as an artist, you're being inspired, that's different from copying. And I'm not, my lens and my bias is on behalf of the brands, right? I represent rights owners, so I'm never going to represent an infringer. I'm always going to be on the rights owner side. So having said that, people take inspiration from other things. That still requires, in this context, that they're creating something anew, right? Are they copying or are they creating? And if you look at that story about Virgil Abloh, which you can Google it to learn more about it, but the key is, are you reproducing? Are you deceiving? So just something to think about from the inspiration perspective, which the artist in me or in all of us would say, we get inspired from everything around the world. Then you go into imitation. And imitation, which if you look at the definition, imitation is obviously, an attempt to copy, right? Where you're not trying to be inspired and to create something new. You're arguably trying to deceive. And I think it's important to think about this in the context of a trademark, because trademark, no matter what country you're in, is all about likelihood of consumer confusion, right? How is the product resembling the other product? And we'll dissect that momentarily. But if there's an imitation where you're, to me, attempting to deceive, offside. That's where you're moving out of the world of being inspired and into the world of imitation, or arguably, said another way, infringement. And to me, this is the fun lawyer part about dupe culture. Is the product infringing? And you must, as counsel, for the brands that are on the call and for the lawyers that are on the call, what do we enjoy doing? We enjoy breaking it down legally. So you've got a trademark, right? So number one, is it a slogan? Is it a word? Does the dupe use the brand elements associated with the imitation copy? So if you think about, for example, dupe culture today, the brand elements from a trademark perspective are being stripped. They're not using the brand name. They're certainly not using the slogan. It'll be a generic version of the brand's good. And we'll talk a little bit about what that means. Then you have to think about it from the copyright perspective, right? Is it an artistic work that is being infringed? And that's different from trademark, right? Trademark is likelihood of consumer confusion. Think of when you think of a copyright, you can think of an artistic work, certainly something easy as a film or video or music or a sculpture, for example. That's where you get into the world of artistic works. And from a legal perspective, words matter. It's from a copyright perspective, is the work being reproduced? Whereas if you think of trademark, you think is the good being used, right? Is the trademark being used from an infringement perspective? Then you go into copyright. And from there, you then get into the even more fun thing. So in Canada, for example, there's industrial designs, which is similar to trade dress in the United States. In Canada, there's believe it or not, trademark 3D protection for trademarks, which you have in lots of other jurisdictions as well. So a 3D trademark, or think of a design, not the utilitarian function, but think about the actual item that's being reproduced or being copied or being used. Is that design being infringed? And a lot of the dupes today fall into the world of copyright infringement or fall into the world of 3D design infringement from a trademark perspective. and brand dilution. Canada has a really interesting area of law. It's called depreciation of the value of goodwill. And a lot of the dupes today arguably dilute the brand and depreciate the value of the brand. And that's really, from a lawyer's perspective, the fun part of trying to attack dupe culture. So to me, from the perspective of the dupe, those are the really fun areas of intellectual property law that we get to analyze, again, on a case-by-case basis. You can't look at it. There's no one set answer for every dupe that's out there. Lawyers get paid because we have to analyze each one individually to see on that pendulum swinging, where is it? Inspiration, or in a lot of cases, infringement.
So moving a little bit now to the anti-counterfeiting area or perspective. David, do you think, what's the legal distinction between a dupe and a counterfeit from this anti-counterfeiting perspective?
Okay, I appreciate the question. What I want to do is look at this from the perspective of a consumer.
Okay.
And I'm a consumer, and for those that don't know me on the call, I own a lot of pairs of shoes, and I own more shoes than my wife and 2 kids combined, and I'm proud of that. So I want to look at this from the perspective of a fan of shoes. And so what I'm going to do right now is do a quick screen share, and I'm going to pull up an image of a pair of shoes. And this is, we can look at this from the perspective of really any pair of shoes. So if you think, for example, of Nike, think of, Air Force Ones or the Jordan 1 silhouette. Right now on the screen is the Yeezy Boost, which is an Adidas pair of shoes, no longer sold anymore. So interesting timing that that I'm using this example. If you think of Puma, you can obviously think of the Speed Cat, but whatever brand you have, there are certain silhouettes, there are certain shoes that are being sold in the marketplace that are synonymous with that brand. And that's important because it's not just for example, the 3 stripes or the leaping cat for Puma or the swoosh for Nike. What I want to do now is remove the trademark layer and look at this from the perspective of the copyright. And right now on the screen is an image of a letter that was written by the Copyright Office to Adidas granting copyright protection for the Yeezy Boost as an artistic work. And there's a couple really important snippets. What I'll do in the chat, if you don't want to look at the screen, I'm just putting up the letter, which I think everyone should read because it really assists in thinking about dupe culture and how to enforce from a counterfeiting perspective or from an infringement perspective. And so if we go back to the screen, the Yeezy Boost is, yes, a shoe has a utilitarian function, and the copyright does not want to protect, obviously, the function associated with the shoe. What the Copyright Office wants to protect, in this case it was the US, is the artistic elements. And there's no question when this shoe was designed, it was a work of art. It had never been before seen in this way. And it's not, for example, just the sole, either the midsole or the heel. It's really the work as a whole. And so why is this important? Because in today's culture, what ends up happening is you have infringers come along and they try and mimic or imitate or are inspired by, they try and create a shoe that looks just like this shoe. They use the same type of art. And I don't care what brand's perspective you want to look at it from, but once a work is considered a copyright, is registrable as a copyright, then what flows from that? If the work has been reproduced in some format, it substantially reproduces the law in Canada. If it's been substantially reproduced, then it's arguably being infringed. And in Canada, counterfeit's not defined in any act. So if it's arguably being infringed, then in Canada, you can go to court and make the argument that it's a counterfeit copy. And so that's the fun part of assessing each individual item on its own. And if you take a look, I'm just going to scroll up really quickly, you'll see what the copyright actually says. Number one, copyright does not provide useful articles as such. That's important from the US language. But historically, you wouldn't think about obtaining copyright protection for a pair of shoes. what was brilliant that was done by this brand, I had no involvement, just to be clear. And a quick shout out to Kenneth Anand. You can Google him. He's the author of Sneaker Law, and he's become you know, a big inspiration to me. And it was him at the time. He was working with Yeezy, and obviously Adidas was working together, partnering with them. But this brilliance in obtaining copyright protection for this work is allowing, in my respectful opinion, is allowing the rights owners to assess infringement from the perspective of the dupe. And to me, the brilliant dupes strip the potentially the trademarks, not the 3D trademarks, but strip the traditional word slogan trademarks associated with these goods, but you can still assess it from the perspective of copyright. And if you're lucky enough to obtain a 3D registration or a design patent or industrial design in Canada, then you have additional tools to actually enforce. To answer your question, and just to quickly sum up, at the end of the day, from an anti-counterfeiting, purely anti-counterfeiting perspective, there must, to me, be infringement of a registered right. You know, can you assess from a common law perspective that the item is counterfeit because the mark is not yet registered? Yes, but it's a much more challenging case as a lawyer to bring forward. And it's not to say that there won't be opportunities to do so. Having said that, if you obtain the registered right and there's an item that is being reproduced or using the registered trademark elements, move into the world of counterfeiting. Now, I have clients in, for example, in the clothing and apparel space. Let's move away from shoes and let's move into the clothing and apparel space. And there are third-party marketplaces that are selling dupes, you know, in today's world, DOOP, because they don't want to get caught within the world of the dupe hashtag, right? So that to me is moving into the world of infringement, where they're trying to evade detection, evade enforcement, and they're using the brand to sell what I'll refer to as the low quality version. The IP lawyer in me gets scared for a number of reasons. Number one, and I'm going to use, for example, track pants and sweatshirts, and there are lots of different dupe versions of these branded goods. The quality of the garments are horrible. If the consumers knew, for example, that the dupe item was being made in a factory by children who don't have the opportunity to go home and sleep at night and are chained to the sewing machines, I don't believe that consumers would want to purchase that dupe. I don't believe that the savings of money would provide the consumer with the incentive to still want to make that purchase. But the truth is, brands play by the rules of the specific country associated with manufacture. The dupe sellers don't. And they don't because they must have that cost savings, because the sole benefit that is being driven by the dupe seller is the margin of profit. And the danger to me is you're having these low quality items that are not the same level of quality as what the brand is selling, but are being marketed as such. And there's so much misinformation being provided today by the influencers who may say things like, it's made in the same factory as legitimate brand, which is a joke. And when I say it's a joke, I mean there's no truth whatsoever to it. But unfortunately in society, a lot of this information is to believe. And Alastair will laugh because what's the first thing the counterfeiter says when they get caught? Oh, we thought it came, you know, it was the midnight shift run. It was the same factory. Well, no, right? The reason that the counterfeiter was caught is because there were mistakes in the labeling or in the quality of the garment. It's not the same. It's not a midnight factory run. It has nothing to do with that. But everyone on this call is sensitive to those issues. The majority of the consumers, absolutely not. So yes, counterfeiting is dangerous, but dupe culture is entering into the world of dangers similar to counterfeiting. And that's what scares me the most. There's a lot of education that needs to take place on the dupe side, which I'm happy for Alastair to share. And more importantly, the brand owners must enforce to the extent that they can, because their brands are being diluted, their goodwill is being damaged as a result of these dupes, and it's coming based on the popularity of the brand. It's coming to the detriment of the brand because of what the brand is doing, which is researching and innovating and creating high quality garments, high quality shoes, high quality apparel, high quality perfumes and fragrances. And the dupes and the counterfeiters generally are not. And obviously we could talk for hours of, to expand on a lot of this, but it's important to recognize that if a rights owner has a legitimate legal basis jurisdictionally to enforce, then absolutely protect that brand and enforce. And that's my obviously inherent bias to this issue.
Okay, let's move to the digital platforms. Dave, what role do platforms like Amazon, TikTok, Instagram play in the dissemination of dupes? And how can the brands enforce their rights in this digital marketplace?
Rafaela,
So
just 1 minute to let our audience know that they can share the question with the lecturers in the chat.
Yeah, so if anyone has questions, you can write them on the chat. And so if we have the time, they will answer all of them, but if not, we'll pick some. But going back to David and the digital platforms.
Yes, so a couple things. Number one, that's your second $1 million question that you're asking me. Yeah. This is what everyone wants to know. I will say that in 2025, looking at it from the perspective of how this is shaking out versus 10 plus years ago is different. And the reason I say that is because the volume of merchandise available, or the volume of dupe goods available on third-party marketplaces and social media, is incredibly high. And if you have a popular brand, then unfortunately that brand's being infringed, and the volume is massive, which means rights owners have no choice but to work together with platforms. And historically, when your enemy or the infringer is selling counterfeit, the thought would be litigate and be combative and find a solution through court or through some other acrimonious process. I believe as a result of e-commerce today and its power, there's no choice to do that anymore. Number one, it's very expensive. Most brands can't afford it. But more importantly, you're likely to achieve better results by working together with the platform. And rest assured that these platforms are the sellers of the infringing goods. And so, yes, you're working collaboratively, but, keep your friends close, keep your enemies closer. Just be mindful that the predominant business model of third-party marketplaces and social media is for content to remain live. And what the rights owners are doing is negatively, presumably impacting the business model of these intermediaries. So it's important when you get in bed together with the intermediary and work together with that platform that there will always be that give and take. So that's a long-winded way of saying you must proactively work together, but be careful who you're working with. Excuse me. So if we look at each respective third-party marketplace or social media outlet, there are policies available. There are forms available for what I will refer to as the big marketplaces, the big social media outlets, which will provide you with the legal right to enforce. And there are vendors available to your brand that can help, en masse submit takedowns, not only monitor and detect the infringement, but also provide submissions to these platforms to remove the infringement in large quantities. I think it's important to point out that there's no one-stop available shop. There's many different vendors available. There's many different platforms where you may have to prioritize. I think from a rights owner's perspective, the role in working together, or I should say the platform's role in working with the rights owner, to me, is to try and prevent the continued recidivist infringer. The low-hanging fruit, the counterfeiters or the dupe sellers that will stop is easy. It's what do we do about the ones that continue to pop up all the time? And when you're in a popular brand that's being infringed, unfortunately, creating a program and starting a program does not mean there's a solution and an end to the infringement. If the brand remains popular, there will be a continuation every month and probably an increase every month of the volume that's being sold on these marketplaces and being advertised on social media. That's a tough sell. As you know, as counsel that's involved in this and as vendors that are assisting with this, it is really difficult to wrap your head around the fact that it is a continuing, ongoing effort. So to me, the role that the platforms play, and if there's a wish list for platforms, it's do better, right? Do more. The platforms are the ones that have the relationships with these sellers. And it's not enough to just turn a blind eye and say, well, we're a third-party marketplace and we're not listing the goods, but it's the seller that you have to deal with. No, I don't accept that statement. As a lawyer representing rights owners, I believe that the third-party intermediaries are obligated to do more. And there are cases in the US, cases in other countries around the world where courts have come out to support rights owners. The challenge is what the rights owners do is they review what the platforms do is they review that case, they look at the case law, they create a defense to a potential lawsuit, they create a potential solution, a form or an expansion of their policies, and they look at it from the perspective of, great, now we can't get sued and we won't be infringing because we're doing enough to help support the enforcement of intellectual property rights. I don't accept that. The lawyer in me says no, the platforms have to do better and do more, and there is such a high volume of garbage being sold on platforms, and I won't mention any third-party marketplaces by name because this is being recorded, but to me, the platforms that come out and promote the volume of takedowns on their actual platform, and we take down X number a year, and we have X number of employees and X number of dollars that we are contributing towards the intellectual property rights owner world and the removal of this content. I say back to them, how much garbage is still there? Don't tell me how much you're doing that many because there's so many available. So I don't look at that as a benefit to the platform. I think quite the opposite. It's because the volume is so high of infringement. So the bias in me, which is inherent, but more importantly, the rights owner perspective in me says, these platforms must look at this from the perspective of the rights owner better and more effectively. And I see lots of chatter, which I'm trying not to read as I'm looking at the camera.
But there's a very it's a comment
Good.
and a question, and I will begin with you, and then I will move to Alastair. So the effective way to prevent dupe in social media could be to mediate the content of platforms.
Correct.
What do you think? Yeah.
Correct. These platforms, right? There's no regulation, or I should say there's little regulation on these platforms, and there's so much danger associated with them that, for example, if the platform is going to allow the content to be uploaded immediately, right? Think about what is social media. It's speed of impressions and interactions with other users, and it's the ability to be out there first. That's great if it's, for example, there's a benefit to society where the providing real information, not fake news, but providing real information to the most number of people, that's a phenomenal benefit that social media, for example, plays in today's society. But if it's about selling goods, or think about it from third-party marketplace, if it's about selling goods and if it's about consumer protection, why would your model be focused on immediacy and getting it done quickly? Why wouldn't it be more focused on getting it done right? On having a mechanism in place that only the real goods get to be sold. And if we move back into the physical market world, before e-commerce even existed, the onus was on the retailer to ensure that the goods that they would sell to the public were real. they had to sign a contract with the brand to get real goods before they could sell it or risk real legal liability. Unfortunately, right? So that's why consumers, for example, for counterfeits would go to marketplaces and go to flea markets. That's why traditionally that's where the counterfeits were being sold, because there were less checks and balances in those marketplaces. Why should e-commerce platforms function like flea markets? To me, it's crazy. And if consumers knew when they were in a third-party marketplace that they were buying from some guy in a dark alleyway in a cash transaction, they would never buy it. But they don't know. And that to me is the crazy part. So yes, regulation and proper procedures in place are needed by these third-party marketplaces and social media platforms. And it's why you'll never see me work for any of them, because they hate what I have to say, right? I'm never gonna support the way their business model works, because it's so damaging to brands.
Yeah, okay. I will. There's another question which I think it's interesting, because I think the audience really wants to hear your opinions. So I will that both of you answer that. So the question is whether you guys consider it a legitimate or at least acceptable argument by the dupe sellers that they are actually promoting and fostering consumer interest for the original product rather than harming it. I think we know the answer, but yeah, let's hear you.
Okay, I'm going to take this, Alastair, if you don't mind. Shocking, but I want to jump in. So, two schools of thought here. Number one, absolutely not. Any interest that is desired by the brand is not for a copycat. That is the brands that are registering and protecting their rights and are regularly not only communicating with marketplaces but involved in actions in court. They don't want that attention. They never asked for it and they don't want it. But what I wanted to do is tell you a quick story, because I mentioned that Virgil Abloh is my favorite designer. And he's a designer, and he has his own brand. It was called Off-White, which is still around today. But there's a quote from Virgil Abloh that the counterfeits never bothered him. And when that quote came out, it bothered me to my core. And it bothered my core because you had a designer that was creating and innovating, and why would he come out not in support of counterfeiters, but in indifference to counterfeiting when it could destroy his brand? There are brands out there that don't exist today because counterfeiters ended up taking over the business and eliminating those jobs. So that is what speaks to me, right? So when it comes to a dupe seller that, you know, for example, would provide promotion to that brand, it's the opposite. To me, the dupe seller is taking sales away from the brand and is devaluing the brand by creating a lower quality alternative that not only is it lower quality, that unfortunately consumers may believe is somehow associated or affiliated with the brand. And just to segue really quickly, what some brands are doing now is they're creating their own lower quality alternatives. So they're competing with themselves to try and eliminate those sales to the dupe sellers. So the quick answer to that question is absolutely not. The brands want attention for the goods that they're selling, and they don't want any attention associated with anything else. And again, that's just my opinion, not speaking on behalf of any of my clients.
Okay, there's another question about brands which are engaging themselves into collabs. So aren't the brands blurring the line themselves by engaging to collabs that can dilute their exclusivity by associating them with others? What do you guys think?
I'm going to put my sneaker hat on again and tell a quick story. So the Christian Dior collaboration with Nike, there was a pair, I should say 2,000 pairs of highs and lows of the Jordan 1 silhouette. It was called the Air Dior. You can go Google it. And to me, it did not dilute exclusivity. To me, it increased exclusivity. There were so few items being sold, and that was a phenomenally successful collaboration where the counterfeits were found in the marketplace even before the legitimate was available for sale. True story. And so to me, collaborations are the present and the future, and what brands are doing is they're trying to increase the consumers that are interested in that brand. And there's brands out there that all they do is collaborate, right? So there's a brand where it's just, you know, designed to work with other brands. And I would say that this is the current culture and the world that we live in. And from a consumer perspective, it's great because you learn about designers and artists that you wouldn't otherwise be exposed to. But as it relates to what that does to the brand and blurring the line, no way. I say that it, if used effectively, is a tool to absolutely benefit the popularity of that brand and not diminish exclusivity, sometimes even increase exclusivity. And so more consumers want it, less are available to buy it. If anyone has a real pair of the Air Dior's, let me know. I'm dying to get them. I tried tooth and nail to buy those. Impossible.
And especially if you like the two brands. There's a collab, a recent collab between Loewe and On. And I think that's going great. I mean, and if you like the two brands and mix a little bit of a luxury thing and the sportive side, it's great. Yeah, the thing is that's too expensive, but it's, yeah.
Correct. And I will say, when it comes to the luxury brands, and I'm not going to mention any specifically, but I heard rumors from some of the luxury brands that the typical consumer for a high-end luxury brand who would never be caught dead in a pair of sneakers, it may bother that consumer, but from the world at large, and obviously I'm biased as a sneakerhead, but from the world at large, to be exposed to high-end luxury that you would otherwise not even necessarily have heard of, it is a phenomenal tool available to the brand, and if done right, I think can do amazing things.
Yeah. So guys, final thoughts. I mean, Alastair, what would you like to say to the audience? Maybe telling a little bit about your role with INTA. I think it's, yeah. So whatever you want, and then we finish with David.
That was perfect, and I will not even try to articulate that in a more effective way. I will put in my chat my email address. I love talking about dupes. I love talking about IP law. Feel free to reach out to me anytime if you have any follow-up questions. This is, we really appreciate the opportunity to come and speak and provide our perspective on these issues. So thank you for having us, and I hope everyone has a great day.